Hello friends, Supreme Court has recently given a judgment in favor of sub-classification within SC reservation as well as ST reservation. Now the question is whether creamy layer is going to be introduced within SC reservation. Some scholars have argued that creamy layer is not the part of that judgment, but there is a fear that it might be misused to attack SC reservation. With me is Dr. Umakant, who has studied at JNU. He has done PhD at Center for Political Studies, and he has been a founding member of UDSF. Dr. Umakant has worked for a long time, especially with the human rights of the Dalit, and his book about the caste atrocities in Bihar is also coming out very soon. So, Dr. Umakant, I would like to ask you that how do you look at this judgment? Do you see this judgment as an attack on social justice, or would you agree with some scholars who are writing in the newspaper who say that it will enforce the struggle for equality within the SC community? So many of our friends who have not read that judgment, it will be very helpful if Dr. Umakant, who is a scholar and activist, who could share his view on the judgment. Sir.
Thank you for giving me this opportunity to speak today about the latest judgment of the Supreme Court about the issue of sub-classification among the scheduled caste and scheduled tribe community in India. See, reservation has been a very contentious issue in this country right from the beginning. All non-SC and ST people are very critical, very hostile about since time immemorial in that sense, since a long time in the history of India. At least from the time reservation started for the downtrodden community like Dalits and Adivasis. So I am not surprised in that sense that there is an attack on reservation for scheduled caste and scheduled tribes all the time. And even later on, when the reservation for other backward castes started, they also became target of the caste Hindu attack on reservation. So in that sense, I am not at all surprised that why such kind of disappointing judgment has come from the Supreme Court. I am saying disappointing desperately, deliberately, but not with the intention of a contempt. I have nothing personal against the judges, so my critical analysis of the judgment should not be seen as a contempt of the court judgment. That is the request. Now let me point out certain things which I found very disappointing. First of all, what is the basis on which reservation? There is a provision for reservation in the Constituent Assembly of India when it was being debated and discussed. What were those factors which forced them to initiate a process through which reservation or say affirmative action policy would become part of the government structure, governance process in this country? So it was realized that due to socio-educational, cultural backwardness, there are certain communities which have remained outside the mainstream. So in order to bring them into the so-called national mainstream, state needs to provide them some kind of support, some kind of affirmative support. So that's why in India we call affirmative action policy as reservation policy. So that's how reservation started. Reservation policy started. But then one should also understand that is there a problem with the policy, or is there a problem with the implementation of the policy, because of which it has not shown good result for large number of people who have remained outside the fold of the reservation policy, because that is the ground on which it is being said that there is a need to reclassify the caste and communities which are part of scheduled caste and scheduled tribe community. And the argument Supreme Court is moving forward with is that caste is not an homogeneous group in this country. So, we cannot treat all scheduled caste as one single unit. That is fine, there is no problem with that kind of understanding. But the problem is, how would you reclassify? On what basis? There can be no economic criteria applied for reclassifying the communities. No, because there is no provision in the constitution for reservation on the basis of economic criteria. I will come later on that why economic criteria has been used by the current government to give reservation to economically weaker section. That I will comment later on. But first let me limit myself to the latest judgment of the Supreme Court, that how it is disappointing. So, they are saying that there is a need to reclassify because a lot of castes have remained outside the fold of the reservation system and they have not received any kind of assistance, any kind of development at all. So, there is no education, there is no representation in government services. So, there is a need to reclassify. Fine, go for reclassification, but at least also tell what would be the ground for reclassification. That you are leaving it blank. You are asking the states to initiate the process for reclassification. Considering the fact that under Article 341 of the Constitution of India, it is the Parliament of India which has a power to reclassify who will remain within the list of scheduled caste, who will remain within the list of scheduled tribes. State assemblies have no power. Then on what basis? Now my question is, on what basis you are asking the states to reclassify scheduled caste? I mean, it is a long judgment, 565 page, which I am very frankly I would admit that I have not read all 565 pages with all the words, no, but I did look at the first 140 pages which was delivered by the Chief Justice of India. On reading it, I found it very patronizing. I found it a deliberate attempt to prove the point that states have a right to reclassify, and it has been, this claim has been supported in the previous judgment, Indira Sahni versus Union of India, which is famously called Mandal judgment. Plus, there is also an attempt to create a situation which is highly unwarranted, uncalled for. But at the same time, since it was a constitution bench, it was a 7-judge constitution bench, I mean other judges have also given their verdict, all 7 judges have given their verdict. So, if you go through their judgments, then also one feels, one who is familiar with the issue of reservation in this country feels that, like, you know, it's not fair at all, it's very unfair. You are putting the blame on those who have already received the benefits of reservation and you want to keep them out now, so that others can be given an opportunity to avail the benefits of reservation policy. That is a wrong way of looking at the problem. That is what I am claiming now, because that is a wrong way of looking at the issue, because, you know, one should understand where does the problem lie. That is what I have been telling my friends and others. Even I was having discussion with Dr. Abhay Kumar earlier, and I was telling that it's see, the problem does not lie with the policy. The problem lies with the way in which it is implemented. I will give you an example, that when a university or a college advertises for a post, and then they would say that these are the eligibility for anyone to apply. So, in a particular subject like say political science or history or sociology or any other subject. So, they will list out the eligibility factors, who can apply, who cannot apply. After receiving the application, they will see that there are too many candidates, we cannot call them, all of them for interview. So, they will add a desirable qualification about which they had not mentioned in the advertisement at all. And according to that desirable qualification, they will say we will shortlist only those applicants who have teaching experience. So, that is one way of eliminating the candidates. The other way of eliminating the candidates would be like, oh, you have teaching experience, but you do not have publications. See, considering the fact that it is an entry level opening in a university or college, you cannot make conditions which is not there in the UGC regulation. See, publication or teaching experience matters for associate professor and professor post, but for an entry level post like assistant professor, if teaching experience and publication in a reputed journal accredited by UGC becomes the essential requirement, then most of the candidates will not be able to even apply, forget about getting selected. Because see, from where will one get experience of teaching if you are not selected? I mean, one does not get teaching experience while before being born in a mother's tomb,
Sir, I would like to share my experience with what you are saying. Recently, Ambedkar University in Delhi has advertised a post for political science. I have a NET, I have a PhD. I could not apply because there were two conditions which were part of essential qualification, not even desirable qualification, that you should have two publications from your PhD work published in I think in reputed journal, and you should have submitted or you should have presented your paper in a seminar from your PhD work, and that seminar should have been supported by UGC or ICSR. You tell me how many candidates in this country, I have studied from JNU, how many candidates in this country, even I cannot qualify those requirements and those desirable or essential qualification, how many people can qualify? So, this is also one way of excluding majority of the people.
Yes, that's why I was saying that, like, people don't get teaching experience while being in the mother's womb, and then only you are born. So, you are not born with a teaching experience. You get experience only when you get appointed and when you are allowed to teach, then only you will get experience. And the question of having a good publication would also be applicable when you have good teaching experience and you have attended so many seminars and conferences and you have also published. So, for your promotion and for your fresh appointment as associate professor, there are such kind of requirements, but to my knowledge in the UGC regulation 2018 there is no such kind of regulation. So, that is one way of eliminating people. So, what we have in this country is that in the name of selection, it is not selection which takes place, it is elimination of candidates which takes place. So, there are several ways of eliminating candidates, and finally what they would say, because they do not want any candidates from reserved category of SC, ST or OBC to be appointed, so they would say not found suitable. So, this is how in most of the cases. I am not saying even for a moment that good candidates are not selected at all, they do get selected. There are plus many other consideration for getting people to be selected, but this is also a part of the reality that in the name of selection, large number of candidates are basically eliminated, and this is the biggest problem, because of which you find discrepancy in the way reservation is implemented in this country, and that's also reflect that why certain caste and community people are more represented, whereas a large number of people are less represented. So, instead of looking at the problem from this perspective, if you are saying that no, there is a creamy layer section which has developed within the community and there needs to be chucked out, if that is your way of looking at the problem, then it is highly problematic. That is why I am saying that, like, it's highly disappointing judgment that instead of looking at the problem and trying to find a solution, the court have once again failed, as they have failed in the past on the question of reservation issue for SCs, STs and OBC, and this is not the first time, and perhaps this is not the last time, because there are many other related issues on which we need to debate and discuss, so that we can have a clarity and try to address the problem in a more systematic way, in a more rational way, instead of demeaning people, instead of sermonizing people, instead of patronizing people, as if the wretched of the earth are being bestowed with so many things by the privileged caste people in this country. So I would urge everyone to read the judgment first and then debate and discuss that what is the good part of it and what is the bad part of it, why the bad part has become more highlighted than the good part, and why good part always remains a non-starter in that sense. So I would request again everyone to dispassionately look at it.
Dr. Umakant, you have said earlier that this judgment is very much patronizing. So would you say something more about it? Why?
See, it seems patronizing in a sense that, like, something great is bestowed on the wretched of the earth. That 50, 60, 75 years of reservation in this country so far, the privileged caste and community people have given, out of charity to the people, deprived community people, the Dalits and Adivasis. So they should be feeling great about this, and now they are trying to rectify the issue. With that kind of mentality, if you approach the problem, then it becomes very patronizing, because the tone and tenor itself it's highly patronizing, that we are doing a great service to you by rectifying the problem, by identifying certain things that has not been taken care of, and in the process, if you read the judgment, the way the issue of creamy layer has been dealt with, it's highly demeaning also, because the judge who has talked about the creamy layer, he says that those beneficiaries of the reservation system who have already benefited, they don't want to give up things, and their mentality is like a general compartment mentality. What does that mean? That means people who are familiar with the Indian Railway, in the general compartment, the people who do not have reservation of berth, they go through general compartment and they capture the seat. They do not want to share their seat with others.
So once you enter the train,
yes,
you do not want others to share your coach.
Yes. So if that kind of demeaning attitude is there with the judge to describe the situation, and that becomes a ground for justifying the call for creamy layer and keeping them out of the reservation process, then I think it is not only patronizing, but it is also demeaning. You are demeaning people, that you have taken enough of it, now let's get out of it, otherwise we will throw you out. So with that kind of approach, it should not be dealt with. That's what I am pleading here. And secondly, the manner in which reservation policy has been dealt with in this country since the time it started, the people who have been at the helm of affairs, they have a very patronizing attitude towards the Dalits and Adivasis specifically, with the intention of always keeping them within their limit. So, they do not like anyone from that community to challenge their authority. So, it is like keeping them within their limit, that look, you are a Dalit, you do not have a right to question, we are giving you something. So, don't cry all the time and don't shout all the time that you are not getting justice. So, with that kind of attitude is very patronizing in that sense, and also sermonizing. Sermonizing, I would say, because see, in our country we do not follow a system of religious jurisprudence. If you read the judgments of most of the judges, especially related to the issues of scheduled castes, scheduled tribes and OBCs, you would find the judgment very sermonizing, in a sense that the judges feel free to quote from the religious Hindu text to justify their argument. I mean, this is highly atrocious, highly unwarranted, highly uncalled for. I mean, how can you allow a judge to quote from Gita or Ramayana or Mahabharata in that sense? India is not a Hindu state. Indian constitution claims that it is a secular state. How would you react if some judge, say Muslim or even a non-Muslim judge, quotes from Islamic text Quran? How would you react? You would say no, it is not allowed. But if I say that a judge quoting from Gita or Ramayana or Mahabharata cannot do it, it is highly unwarranted, it is highly uncalled for, you would say what prevents him or her from quoting from the Ramayana and Mahabharata? But then I will have a counter question, which law permits you to quote from Ramayana, Mahabharata and Gita while delivering a judgment? You may be a Hindu by your choice, that is your personal, part of your personal life, that cannot become part of your professional life. So, while you are performing your professional duty, you are not supposed to give prominence to your personal opinion. Personal opinion should not come when you are delivering a judgment. Personal opinion should not matter when you are performing your professional duties. So, in your official capacity, you cannot give prominence to your personal choice. That is why I am saying, even in this judgment, these are highly patronizing and sermonizing attitude that is displayed by the judges while delivering the judgment, which is highly objectionable, and I feel the Chief Justice of India, of the Supreme Court of India, should take notice of this, that such kind of things should be avoided, because by giving prominence, you are not only legitimizing certain kind of religious influence, but also giving primacy to one religion. You are not ready to give primacy to other religions. So, why indulge in such kind of discriminatory behavior and attitude? As part of the code of conduct, they should refrain from quoting from religious text of any religion in that sense. I mean, there is enough number of religious enough number of legal resource material available from which you can cite, you can quote, to justify your arguments.
Dr. Umakant, you have read Ambedkar's writing in great detail. Anybody who is even a graduate student and who has read Ambedkar a little bit, what is Ambedkar's key argument? That Indian society is caste based, and one person or a member of one caste cannot be given this responsibility to take care the interest of every community, every caste. That is why there is a concept of representation, and Baba Saheb Ambedkar has said very clearly in the states and minorities that not only proportional representation but also effective representation. To say it, the point which I am trying to highlight is that Indian society which is caste based, and if you look at how scheduled caste or scheduled tribes are represented in, let's say, jobs or in public universities or in business or in media, you will find that still 50, 60, 70, 80 years after independence, you will see that they are not adequately represented. Okay, seats are not fulfilled. Even the legitimate quota, which is 15% or 8% or for OBC 27%, even those are not represented. I have read several reports recently that even in the business classes, even the corporate world, and even in the business, you will find that 97%, 96% people come from two castes, Brahmins and Baniya. So is the case with the media. So why, when the Supreme Court and the honorable judges, the learned judges, when they are writing their judgment and when they are hearing this case, why don't they look into the wider picture? First, SC reservation, ST reservations, OBC reservations are not being fulfilled. Backlogs seats have not been fulfilled. And in private sectors, marginalized communities are nowhere. Film industries, medias, they are also excluded. So why those bigger realities are not looked into, and everything is being reduced to who is creamy, who falls under the creamy layer within the SC community? Why such kind of debate is giving so much prominence, that now the ruling establishment is very much determined to do away with the SC or ST or OBC reservation? Is it the intensifications of the counter-revolutionary forces?
See, what has been the experience so far in this country is again an issue of concern, in a sense that the manner in which reservation has been implemented, it tells many stories. It tells many stories of discrimination, deprivation, and it tells the stories of how patronizing attitude has been at play by the people who are at the helm of affairs. I will give you some example that how it has been implemented, and plus also later on add many other things of consideration which should be considered in a much more rational way. See, reservation per se should be implemented in all the government departments, because there is no reservation in the private sector. That again is an issue on which I will comment little later. But let me first talk about the reservation that is implemented in the government sector, in the education institution, in the government jobs. Even for getting admission into education institution, who gets the admission? So there is a general category, there is a SC category, there is a ST category, and there is OBC category. So the general category has 49.5% reservation, that is also a reservation, and then 22.5% for SC and ST and 27% for OBC. So there is a cutoff for all the categories. Those who fall under the category, those who have marks under the cutoff, only they will get the admission. So that is one way of selecting people, and that is also a way of eliminating people. So those who have got good education obviously will have good number, and they will have a good number, and they will come under the cutoff, and they will get the admission. So people who have studied in a backward district will not have a fair competition with people who have studied in the urban areas. I mean, why can't we have same kind of education facilities all over the country? Why urban areas have better facilities and rural areas or partly urban areas have less facilities? So, that government should look into, and instead of blaming the reservation policy, instead of blaming the so called creamy layer among the SCs and STs and OBCs, they should actually be talking about improving the access to education, improving the quality of education at every level in this country. That we do not hear from them. So, that's an issue of concern. And the secondly, how do, like you were asking me that, like, there are problems in several other sectors. It is not just education and government job sector where you have problem. Media, you have no representation. Corporate sector, you have no reservation. Journalism,
cinema,
culture, you name anything. Science and technology. See, if you remember, I was telling you once that, like, there are highly contradictory judgments. Highly contradictory. This judgment and even the previous judgments, they are highly contradictory. In a sense that, I will give you an example of, like, say, the case, that famous Mandal case, Indira Sahni versus Union of India. One of the judges, that was a 9-bench constitution bench. One of the judges in that judgment said that reservation is not against merit. Why I am saying contradictory? That the same judge also said that, but reservation cannot be applied in super speciality courses. What is super speciality courses? Like science and technology, like medicine, defense and many other sectors like that. But if you are saying reservation is not against merit, then how are you saying that reservation cannot be given in super speciality courses? So, this
is same castic law.
Yes.
Castic logic.
Yes. You are contradicting your own self.
Here you can give reservation,
but there you cannot give reservation.
Because it is very meritorious.
Yes, yes. You are saying that reservation is not against merit. But at the same time you are saying, no, there are certain super speciality area where we will not give you reservation, only merit will work. Now you are saying there is a creamy layer within the Dalit community, Adivasi community and OBC community. Which community has a creamy layer in actual practice? Which community? Because a former Chief Justice of India's son can become the Chief Justice of India in future. Is that a creamy layer community or a community whose only second generation has been able to get reservation?